to one and all. I, Janki Patil, feel privileged to extend my warm welcome to our esteemed guest for today, Advocate Dr. Uday Warunjikar, sir. Also welcome our management, our staff and students of our college, and our viewers on YouTube on behalf of Deccan Education Society, Sri Navalmal Firodia Law College, Pune. Our college has organized 2 days national webinar Krushimanthan, a review of agricultural laws. This webinar series will focus on offering a multifold understanding of agricultural laws and farm acts. Our guest speakers will take us to greater depth of clarity and unwind new perspectives for us. It is indeed an honor and privilege to having been given the opportunity to host our guest speaker for today, Advocate Dr. Uday Warunjikar, Sir. Sir has completed his LLB degree from Pune University in the year 1994. He also holds diploma in labor and taxation law. Sir has been awarded PhD degree in gender justice, human rights and preconceptional and prenatal diagnostic technique act 1994 critical appraisal of statutory and judiciary perspective. Sir has been practicing in the High Court at Bombay for more than 27 years and has handled more than 14,900 cases so far in the High Court. Many of them include public interest litigations like implementation of biomedical waste rules, various issues concerning noise pollution, water pollution, as well as air pollution, and many more. Sir has handled various issues concerning rights of female. Sir has also written two Marathi books by name न्यायालयालाच हवंय न्याय आणि समाज स्वास्थ्य आणि न्याय व्यवस्था. Sir has also worked with Sakal and Lok Satta and various Marathi newspapers about legal issues. Not only that, Sir has participated in various talk shows as well as TV channel programs about legal issues and on All India Radio also. Sir was a resource person for training of all judicial officers in Maharashtra. Sir was appointed as a member of expert committee for finalization of syllabus of cyber law in all non-agricultural universities by state of Maharashtra. Sir was member of Bar Council of Maharashtra and Goa and vice president of Bar Association of India. Sir has his expertise in handling thousands of matter pertaining to PWD Act 1995, 1955 and RPWD Act 2016. Sir has received prestigious awards such as Alpavaila Award by NAB, G.N. Nardekar Award, and Karnabadir Mitra Award. Thank you. Now I would like to request Advocate Dr. Uday Warunjikar sir to proceed with his speech.
Sir, join after 3 to 4 minutes. Please wait.
अगं कधी ती खिडकी देखील खिडकी हसे हा जरा भगवद्गीता श्लोक लिख एक दोन
Sir will join meeting shortly. Kindly stay tuned.
Hello everyone. Due to unavoidable situation at Sir's end, Sir will join after some time. So I kindly request everyone to stay tuned. Thank you. We will be starting the session in 2 minutes. I request all of you to stay tuned. Thank you.
Welcome, sir. Good afternoon.
Please start.
Yes, sir. We can start. Sir, can we start?
I said, please start.
So we have done with the introduction part. We can directly start with your speech.
Yes, very good. Are you recording now?
Yes, sir. Yes, sir.
Yes. Very good. Chalo, dear friends, this is a wonderful occasion to meet you once again, but in a different manner, I can say. And nobody even guessed as to how we are going to meet this time. Let me tender my apology for joining late, as I was on my leg before the Honorable High Court arguing a matter, and the matter took a little more time, and I got stuck in that entire hearing. So let me tender apology to all my young friends who are on that side, and let me start now. Uh, the constitutional validity of the farmers' laws or farmer laws is the topic which has been assigned to me. I am aware that all of you are a student of law. As a result of the same, we will not be get swayed by the different emotions, different slogans, different agitations, and the emotional arguments. We as a student of law, we will have to find out whether there is a legal support so far as the actual subject is concerned. Whether there is any substance in the contention of either party, we will have to be impartial. We will have to take a introspection and find out what is the real intention, why this new laws were framed, whether the challenge is having any merit, and all other different things which are there, those will have to be considered. And of course, as I said, that it will have to be done independently. Why? Because the young generation of the students like you are computer friendly, you are social media friendly, and with respect to all your skills, I must say that all of you strongly rely on the social media. But I'm sure you must have thought it. Who is feeding all those data in the social media. Take a case of that Google Mousy, which is there in your mobile or which is there in your laptop or even the desktop. That Google Mousy doesn't have its own independent application of mind. Of course, the artificial intelligence is the field which is altogether different, in respect of which we can talk in some other different session. But unless somebody stores a data in the social media, you won't get any kind of a ready-made answer. So therefore, let me tell you, with respect to all your skills and abilities to search online, let me tell you that this subject is different than conducting a regular online research. Online research is having a limitation, and apart from that, the most important aspect is, as a student of law, you will have to understand the difference between the knowledge and the information. This Google or this social media of which you are an expert will give you information and not a knowledge. So therefore, let us try to convert or transform your information into a knowledge with reference to the today's topic. Now, in these circumstances, as I said, that the first expectation is that there has to be an impartial application of mind. Two, we will have to find a solution within the framework of the present legal system. In other words, we as a student of law, we will have to find out the background of these legislations, assess the validity of that on the touchstone of the Constitution, and then based on which we can draw some conclusion. I am not at all suggesting that you come to A conclusion or B conclusion at this moment. It is left to your own wisdom. But the question is, you will have to do an impartial exercise within the framework of the Constitution. That is more important. And for that particular purpose, let me take all of you back to 1991. Rather, why 1991? We can go back to the debate which took place when the different legislations were framed, or even the Constitution of India was going on. You will come to know that with reference to some of the provisions which are relevant, you can find some roots in the constitutional debate also. Now that constitutional debate will be helpful. I am sure, yes, I am sure you have missed this topic. So therefore, those students who are willing to do some more research and and burn the midnight oil, it will be better if you go to the legislative debates or the parliamentary debates, where you can get some better idea with reference to this topic. Now I'll tell you, with reference to this topic, the material is already available online, and you will come to know that when the Constitution was drafted, the constitutional debate also makes a reference about the topics which are relevant for the purpose of this session. Since the young generation like you are a master of this technology, and you are comfortable in using different tools. So therefore, let me tell you, the constitutional debates are available online also. So you can do that exercise. And what is to be done? You will find that the 7th schedule of the Constitution, you will find there is a list 1, list 2 or list 3. Now in respect of that, you can definitely go to the debate which was going on in respect of the entry number 22 of the state list, which is agriculture, as well as you can go to the other entries which are there in the concurrent list, which are useful with reference to the today's topic. If you go through that, then I'm sure you will get a better idea. Now I am having a material which has been copied from those legislative debates. You will find R.B. Chaudhary Surajmal has spoken on this topic when the debate was going on while framing the constitution. E.T. Krishnamachari, he has spoken. K. Shantanam has spoken. Adili Iyer has spoken. Balkrishna Sharma. So many speakers have spoken about this agricultural aspect and the trade which is involved in the field of agriculture. I'm sure you must have missed this. So therefore, I thought it fit that if you want to find out whether this law is constitutionally valid or otherwise, you will have to go back to 1950 or perhaps prior to that. Having said about this, let me tell you what is the framework of the Constitution. I'm sure as a student of law, you must be having a copy of the Constitution with you. This is that kind of a one small piece, which is a pocket edition of a Constitution. In this pocket edition will cost you hardly 500 or 600 rupees, and you will come to know that every student of law should have his Constitution book ready with you on your table. Now, about the framework in the framework of the Constitution, we are aware that we are having a federal structure, and as a result of that, there are some topics which are assigned to the center who will frame the laws on that topic. There are some topics which are assigned to the state government, and there are some topics which are assigned to both. And you will find Article 246 onward, you will find there are provisions with reference to this particular type of the work which is required to be done. Have you seen that particular topic? If no, please make a note. That is part number 11 of the Constitution of India. Now that speaks about the relation between the union and the state, out of which chapter 1 is legislative relations. The heading is distribution of legislative powers. And you will find Article 245 gives you an idea how those lists have been created. 246 gives a power to the states subject to the sub-article 2 and 3. 247 gives a power to the parliament in respect of the legislative power in respect of the topics which are there. Then residuary powers are under Article 248, and 249 says that though the law is in the state list for national interest, there can be a power which can be exercised by the parliament. Having said about this, have you gone through these provisions or not? That is up to you. But as a student of law, please make a note of this, and you will have to read these different articles. There are judgments on these articles. Having said about the framework of the Constitution, let me tell you some kind of a legislative history is also required to be traced. Because as a student of law, when we are testing the constitutional validity, we will have to find out the legislative history with reference to that particular enactment. Apart from that, the next test and next method which is useful is find out the social situation which was there at that point of time, which will be helpful for the purpose of resolving those issues. Now, in view of this, now let us go back to 1991. We have seen Dr. Uday, Vice Chancellor of National Law University, Maharashtra at Mumbai. He has inaugurated this seminar, and I am proud that I am his student of PhD. He was my guide, under whose guidance I could complete my thesis, and the PhD has been awarded by SPPU. Now, he made a reference about the liberalization post 1991. We are aware about the GATT, we are aware about the World Trade Organization, we are aware about the tariffs which have been introduced, the TRIPS agreement, all these things are aware, we are aware. But that all liberalization was with reference to the other field, most particularly the agricultural revolution, which was there, was excluded from this liberalization. What was the impact thereof? You will find the software industry was one of the classic example where it was something like a boom industry. or even with reference to the law, LPO, you will recollect around 20 years back, the LPO, legal process outsourcing industry, was again at a boom, and the Pune was one of the hub which was known for the LPOs. This all we have noticed, but agricultural field was a exception to that kind of a liberalization. Now, with reference to that, the central government as well as the state government, different state government, they were vigilant, and they realized that there are hurdles so far as the agricultural trade is concerned. There are some shortcomings of the agricultural economy. They also realized that there are drawbacks in the marketing system of the agricultural produce. They also realize that the fragmented agricultural trade supply chain is there, which is one of the important issues. And therefore, apart from all these topics, they also realize that the price of the agricultural produce is one of the hurdle which is faced by everybody. The places where the agricultural produce can be sold is also one of the hurdle. The control and restrictions over the persons who are in charge of deciding the prices, or the places where the agricultural produce can be sold, is also one of the aspects which was realized by them. And then after 1 decade of the liberalization in the year 2000, an expert committee was appointed. The chairman was Shankarlal Guru. You may note down this, the report is also available online. Ministry of Agriculture, central government, they appointed this committee who submitted a report in the month of June 2001. So almost after 1 year, the report was submitted. They made several recommendations, what are the shortcomings and how the things can be improved, based on which an interministerial task force was appointed by the central government in the year July 2001. Why interministerial? Because it was pointed out that the Commerce Ministry is concerned. It was pointed out that the External Ministry is concerned. It was pointed out that the taxes are also correlated with this. It was pointed out that the Agriculture Ministry is there. It was pointed out that there are several other departments who are also having some contribution in resolving these issues. In view of that, the interministerial task force was appointed. The ministers of different departments of the central government, they came together, they accepted the report, they made a recommendation, and they gave two important suggestions. That was with reference to the Agricultural Produce Market Committee legislations will have to be strengthened. And the second was the amendment in the Essential Commodity Act was required. So these were the two important suggestions which were given, two recommendations which were made 2 decades back, namely 20 years back. This is again available online, you can check that. Based on which in 2003, the Model APMC Act was drafted by the central government. Because the APMC Act has been prepared by the different legislations in a different manner, and those legislations, state legislations are having their own priorities. As a result of that, the state legislations have drafted their own different Agricultural Produce Market Committee Act. The committee came to the conclusion that there is a need for the Model APMC Act which can be strengthened in view of the recommendation. The Model APMC rules were also framed in the year 2007. Now, those were partly accepted by different states. Some states adopted fully, some states adopted partly, and it ultimately resulted into some kind of a confusion further, because the object was to strengthen the mechanism. It was not getting strengthened effectively, and therefore again in the year 2013, namely after one more decade, the empowered committee of 10 state ministers in charge of agriculture and marketing was constituted. So 2010, this committee was constituted where the ministers of agriculture from 10 different states were brought together, and they were asked to again deliberate on these issues. They consulted farmers, they consulted farmers organization. In 2013, they gave a report. Now there was a working group on agriculture production was also constituted, where the Chief Minister of Haryana, Chief Minister of West Bengal, Chief Minister of Punjab were also member. They also made certain recommendation. Again in 2017, the Model Act was prepared with an object of having a free trade with reference to the agricultural produce. Now, those draft were again prepared by the central government, and those were circulated to the different state government so that those can be considered and adopted by them. Then again, some suggestions were made in 2018. You will find the Model Act was prepared with name Agriculture, Produce and Livestock, Contract Farming and Services Act 2018. Some states again adopted, some states said that no, it can't be done. And in these circumstances, a ordinance came to be enacted. That ordinance, there were three ordinances. One is about the amendment in the essential commodity, and two were about the farmers, namely the price assurance ordinance, which is popularly known, and second was trade and commerce ordinance, which is again known. But that ordinance got repealed because the bill was tabled in the parliament, and it was passed, and it was gazetted in the month of September, namely on 27 September 2020. So this is that legislative history which we are aware. Now let us go to the social history with reference to the farmer laws. We are aware that there are a number of organizations which are in the field. Those organizations are dealing with different issues. There are organizations which are having political affinity. There are organizations which are having a ideological affinity. But apart from that, the most important aspect was all of them were having a common agenda, namely now the farmers are the persons who should be brought in the mainstream. Let us go back to the Gandhi era. We are aware that Mahatma Gandhiji had said that 20% India stays in the city and 80% India stays in the rural part. That was at the time when we got an independence. If we consider the today's position, we are aware that almost 50% of the state of Maharashtra is urbanized. As a result of that, we can roughly draw a conclusion that only 50% is a rural Maharashtra. What is the impact of that? There are the farmers who are compelled to commit a suicide. There are farmers who are depending on the nature's calamity and other several issues. There are farmers who are throwing their agriculture produce or the livestock produce on the roads or in the gutter. There are agriculturists who are not sustaining the agriculture activity financially. So this was that situation which was prevailing at that point of time. As a result of that, you will come to know that simultaneously on the social front, there were various NGOs which were taking a lead for giving some kind of a relief to the agricultural laborers or the agricultural producers, and the organizations were also the same. In the last few years, you will come to know that weekly farmers markets were floated in the urban area of the state of Maharashtra. Weekly farmer market or direct produce from the agriculture field was brought to the markets directly. There were persons who were, there were organizations who were trying to eliminate those intermediaries like Adatya or Dalal or several persons. There were some states who were taking a lead in decentralization of the APMC. State of Maharashtra also introduced the private market committees by making an amendment in the APMC Act. All kind of different activities were going on the other hand. So if we club the legislative history and the social situation which was prevailing at that point of time, we will come to know that the situation was getting ready for the further transformation. What kind of a transformation? And therefore, I am going to suggest all of you that you will have to download the bill which is available for the purpose of perusal. I have done that. This is that bill which is available. This kind of a bill is available online. I am sure you can get it downloaded immediately. There is one more website which I can tell you immediately, PRS, where legislative research are made. You will come to know the comparison of different bills are also made available as a source of information to us. But apart from that, as a student of law, we will have to go to the statement and object, statement of object and reasons of each such bill. The bill which is tabled in the parliament or in the state legislative assembly, you will come to know there are such kind of a statement and statement of object and reasons which are there. I am having a bill in front of me which is Farmers Produce Trade and Commerce in bracket Promotion and Facilitation Bill 2020, and I am reading statement of object and reasons which will give you some sufficient idea. Para 4 of the same says, to keep pace with the dynamically changing agri-economy and e-commerce and agro experts, and also to meet rising expectations of the farmers and consumers, the country needs an accessible and competitive trading system outside the physical space of notified market yard under the State APMC Act. So this is what I was telling you. Para 4 is that throws the light as to why the new act was enacted. I'll read some part of the para 5 of that statement of object and reason. In the light of the above circumstances, it has become necessary to enact a central legislation to provide more competitive and hassle-free ecosystem where farmers and traders have the choice to sell their produce in an efficient, transparent and competitive environment to realize remunerative prices. So this is that object which will have to be kept in mind, and while testing the constitutional validity, we will have to find out the source of the power from the Constitution. Let us do this exercise for the second legislation. The second legislation is having a name Farmers in bracket Empowerment and Protection bracket Complete Agreement on Price Assurance and Farm Services Bill. This is a bill which was again tabled in the Parliament. The statement of object and reason is also there, and I'll read some portion which will give you a better idea why the new legislation was introduced. It says Indian agriculture is characterized by fragmentation due to small holdings and has a certain weakness such as dependence on the weather, uncertainties in the production and unpredictable market. This makes agriculture risky and inefficient in respect of both input and output management. These challenges needed to be addressed by way of realizing higher productivity, cost-effective production and efficient monetization of the produce to increase the farmer's income. This is that aspect which will have to be kept in mind. And it says that what are the provisions which are to be done. Now, the para 2 part of that says, and as agriculture sector has immense potential to make significant contribution to the economic growth, there was a need to find long-term solution for farmers and agriculture as a whole. So therefore, this was an object with which certain suggestions were made, certain new schemes were, new provisions were made. On the same line, you will find the third legislation is about the amendment in the Essential Commodity Act. And I'll read the similar, I'll read para 2 of the statement and object and reason of that Essential Commodity Amendment Act 2020, para 2. While India has become a surplus in most agriculture commodities, farmers have been unable to get better prices due to lack of investment in the cold storage, warehouse, processing, and export as an entrepreneur get discouraged by the regulatory mechanism in the Essential Commodity Act 1955. High Power Committee of Chief Ministers who examined this issue recommended removal of stringent restrictions on stock, movement and price control of the agricultural foodstuff for attracting private investment in the agriculture marketing and infrastructure. So this is that object which is to be kept in mind. Now, having said about this, Now let us enter into the core subject, namely the what is that challenge with reference to constitutionality. Now I have seen different petitions which have been filed before the Honorable Supreme Court of India. We are aware that there are several petitions which are pending before the Honorable Supreme Court of India, and with reference to that, the basic challenges, I have prepared a small list of those different challenges, and you will come to know that the main challenge is that the legislation is ultra virus to the constitution. This is first challenge. Why they are saying so? Because they are saying that in the framework of the constitution, there are legislative powers which have been given to three organs. Rather, one is under Schedule 7 list A, that is to center exclusively. Then B will be state list, which is for the state exclusively, and C concurrent list. So they said that this is an encroachment because the agriculture is an entry which you will find under the state list, that is item number 14 read with item number 18, entry number 14 and entry number 18. So therefore we can say that this is that particular entry which was placed into service by the petitioners. Those petitioners were making a submission that this is an encroachment on the power of the state government, and the state could have done this, not the central. Second aspect is this: they realize that there may be some answer, because under the concurrent list there are item number 33, entry number 33, which is about the trade and commerce and the production, supply and distribution of the different product. So therefore they realize that there may be a answer to or counter to entry number 14 and 18 of the state list by entry number 33 of the concurrent list. Therefore they came with the case to apply pith and substance theory. Please make a note of this. Pith and substance theory was placed into service by them. They made a submission that find out the real intention and then remove that kind of an encroachment. This kind of a submission was advanced by them. Then two provisions of the Farmers Empowerment Protection Agreement on Price Assurance and Farm Services Act was challenged. Those who are interested, they may note down section 18 and 19, more particularly was challenged. And I must tell you, in large number of these petitions, which were clubbed by the Honorable Supreme Court, there were three groups. One group was which was in minority, which was making a complaint about the agitations and the law and order problem which was created by the agitators. That was in minority. Then the second group which was there who were supporting the farmers bill. And the third group was those petitioners who were opposing the farmers bill. Those petitioners challenged only two provisions, namely section 18 and 19 of that act. But let me tell you, in other petitions, there was no challenge with reference to the other provisions of law. So therefore, in other words, with reference to the entire scheme, more particularly essential commodity, more particularly the other two legislation, there was no other challenge. Now, after noticing this kind of submission, the third submission was the redressal mechanism which was introduced under the act was excluding the court, and instead of court there was a mechanism which was created that there will be a creation of a subdivisional magistrate court which will be there who will look into that. So they said that this won't happen, this won't be a correct thing because they are the government servant, and then based on which this won't be a correct thing. Apart from this kind of legal submissions, the most common criticism was made that instead of strengthening the APMC, namely Agriculture Produce Market Committee Act, there is a parallel market system which is being created, and this is not in the interest of the agriculturists. This kind of submission was made. Second submission was with reference to MSP, namely minimum support price, which was to be provided, and there was apprehension that there will be a go by to the minimum support prices. The central government made it clear that neither there will be a parallel market system, nor APMCs will be abolished, and nor the MSP system will be abolished. Let me tell you one more important aspect at this juncture, that there is no law which guarantees MSP, nor the MSP system is placed before all students. Now, having said about this, uh, the one more criticism was made that now the private players will be allowed to have an interaction with the state government, with the farmers, and they felt that no, this is disastrous, and wherever those private players have come, they have destroyed the society of a farmer. So this was one more allegation which was made. Now they also made an allegation that no consultation was made, but central government came with the defense that the consultation was made, and it was pointed out there was an apprehension that the subsidy will be waived and the subsidy will not be made available. Again, the Supreme Court, again the central government made it clear that sorry, this can't be done, and this will be continued. Subsidy is nothing to do with this present challenges. Having said about this, now let me tell you what can be the legal challenge. With reference to that, let me tell you that a constitutional validity of the legislation, it can be challenged on limited grounds. To start with, I must tell you with the presumption. Presumption is all legislations are intra-virus, all legislations are valid. That is a presumption. So therefore, those who wish to challenge validity, they will have to come with a very strong case to meet that kind of a presumption. Now, apart from this, with reference to the legislation, the legislative competency will have to be tested. This is one of the way how the legislation can be challenged on the touchstone of the validity. The second will be a particular provision, whether that provision is arbitrary, whether that provision is unreasonable, whether that provision is ultra vires to the constitution, whether that provision is contrary to some fundamental right. These are the different things which are involved. So let us try to find out the first question, whether there is a legislative competence to the present enactment. You will find I was making a reference about those different entries in the state list and the concurrent list. You are aware that so far as the state list is concerned, entry number 14 speaks about agriculture, including agriculture, education, research, protection against the pest and prevention of plant and diseases. So this is nothing to do with reference to the trade and commerce of which I am making a reference, or the central government has made a reference. Item number entry number 18 of the state list, that makes a reference about the land, that is to say rights in and over the land, land tenure including relationship of landlord and tenant, connection of the rent, transfer, alienation of agricultural land, land improvement, agriculture loans, etc. Again, you will come to know that this is nothing to do with the object which are mentioned in those two legislations, or the object which is sought to be achieved by this new act. Now, this is something altogether different. There may be other few entries like entry number 30 of the state list, which is money lending, money lender relief of agricultural indebtedness. This is again a separate thing. You will come to know entry number 46, which is about taxes on the agriculture income. Again, nothing to do with the present enactment. Then you will find entry number 47 of the state list, duties in respect of succession to the agricultural land. You will find with reference to that, again, the legislation is silent. Then the estate duty in respect of agricultural land is entry number 48. So you will come to know that there are 6 such entries in the state list which empowers the government, a state government, to make a law. But you will come to know that if we apply the test of all these 6 entries to the provisions of this new law, you will come to know that sorry, this is something else. This is nothing to do about the agricultural protection. This is agricultural pest, prevention of plant disease, agriculture education, agriculture research, or land tenure, land improvement, landlord tenant, or even the agricultural loans, or agricultural taxes on the agriculture income, or indebtedness of the agriculturists. These are something different issue. So therefore, let us try to find out where is that competency of the central government to make the law with reference to the entry number 33 of the 7th schedule list number 2. You will come to know entry number 33 of the concurrent list makes a reference to trade and commerce in and the production, supply and distribution of. And then you will come to know that in which you will come to know that there are different products which are mentioned. Those products include food stuff, edible seed oil, cattle fodder, oil cake, other concentrate, raw cotton, gained or ungained raw cotton, cotton seed, raw jute, and several other things are can be included on the same line. Apart from that, you will come to know that there is entry number 41 of the of the concurrent list, which gives power to the central government. Now, having said about this, now we will have to find out whether that section 18 and 19 of the Farmers Act is having a source of power from entry number 33 of the concurrent a few minutes back, or whether those are having a reference to the power which is flowing from those 6 different entries from the state list. This is that argument which will be advanced. Now, having said about this, let me tell you that thereafter the central government filed their reply before the Honorable Supreme Court of India. I have gone through that reply also. In the reply, they pointed out that reply was affirmed on 11th of January 2021. In that reply, the Supreme Court said that the first round of meeting to resolve the dispute took place on 14th of October. Then the second meeting on 13th of November, third meeting on 1st of December, and then in the fourth meeting, which is relevant for the purpose of the present topic, is that took place on 3rd of February, 3rd of December. In that 3rd of December meeting, for the first time, the minutes made a reference with reference to the constitutional validity of these laws. And this subject, namely entry number 14 and 18 of the state list and entry number 33 of the concurrent list, first time came before the meetings which were held for finding out the amicable solution. From that point of time, now the legal battle started. Now I will tell you those minutes of the meetings are also available. So therefore you can get that also. Then the 5th round of meeting was held on 5th of December. Then 6th round on 30th of December. Then 7th round was on 4th of January. And the next round was to be held on 15th of November 21. In these circumstances, when the petition was filed before the Honorable Supreme Court of India, at that point of time the hearing took place and the reply came to be filed by the central government on 11th of January, and immediately on the next day, namely on 12th of January, the Honorable Supreme Court, through the bench of the then Honorable Chief Justice, was pleased to pass a stay order. That stay order was passed on 12th of January. Now, that stay order is also interesting. As a student of law, I must tell you, that stay order makes a reference about the submissions which are advanced. But interestingly, this is something different, some kind of unusual order which came to be passed. After granting a stay, the Honorable Supreme Court appointed a committee and said that let there be a attempt to resolve those issues. Apart from that, when as a student of law, I was going through the live updates which everybody was getting. And those live updates were telling us that all honorable lawyers or respected lawyers were making a submission apart from the constitutional validity. Or other arguments were advanced. Other arguments were virtually in the nature of an emotional argument, virtually about the law and order problem, virtually about the political commitments which were made and the different assurances. So therefore, it was some strange situation when the then Honorable Chief Justice and the two honorable judges of the Supreme Court granted interim relief by way of the stay until further orders. Now, this is that situation where the Honorable Supreme Court passed that order. The matter was to come thereafter, but again, we are aware that the pandemic situation has compelled the Honorable Supreme Court to revert back to the online system, and as a result of that, there are different situation as on today, and I am sure that in near future there will be a effective hearing with reference to this. Now, having said about the constitutional validity aspect, let me come to the second aspect, namely the arbitrariness or unreasonableness of a particular provision. That particular provision which they have challenged is section 18 and 19. Apparently, section 18 and 19 will have to be tested. This is the work which I am giving you as a homework. You will have to find out whether whether section 18 and 19 can be called as a ultra virus to the provisions of the Constitution. And let me tell you, Article 14 contemplates the equality and equal protection of law. In that, this arbitrariness, unreasonableness is a part which is involved. You will come to know Article 19 is there. That Article 19, up to some extent, you will come to know that that is also having some kind of an impact on this. Very limited impact, I can say. Article 21 is there. A right to life. We are aware that life and liberty has been interpreted by the Honorable Supreme Court and the Bombay High Court in multiple judgments, and that has been expanded in such a manner that even with reference to the rights of the farmer, the right to life can also be seen. So therefore, whether that is contrary to section 18 and 19 of that act is violating Article 21, that can be tested. There can be a reference to the DPSP, we are aware. We are aware about Article 38, sub-Article 2, which makes a duty for the government, which says that the government will have to rather endeavor to eliminate inequalities in the status, facilities, opportunities, etc. So therefore, whether this is referable to 38.2, whether this is referable to Article 39C, whether the that can be also a submission which can be advanced. There can be one more submission about Article 43, where a state is supposed to endeavor by making a suitable legislation or economic organization for workers, agricultural or otherwise, etc. So therefore, for agricultural workers, there is Article 43 DPSP, whether we can refer to that. There can be reference to the FD, namely fundamental duties 51C. We are aware that that is again one more duty which is casted on all citizens, which is fundamental duty. So these are the things which we will have to put into our service. Now, having said about this, as I said that I am not going to conclude this debate either this way or that way, because as a student of law, I feel that there is a tremendous scope which is available for my young friends who are on that side, and they can surely develop this topic further. Having said about this, this is a very good, fantastic opportunity which is available for students who can apply their mind and come with some kind of a better submission with reference to the this topic. I must tell you, you can make these are the few topics which I am suggesting as a homework. You can compare the pre-independence legislation about agriculture with post-independent legislation. You can compare pre-liberalization legislation with post-liberalization legislation in India, namely pre-1991 and post-1991 legislations. You can compare the legislations for farmers in the SAARC countries. We are aware there are 7 SAARC countries. So the situation in South Asian countries is somewhat similar. So therefore we can compare legislations of South Asian countries, SAARC countries. There can be a comparison of different legislations where the Commonwealth countries are there. We are aware that Commonwealth countries are governed by, the crown or the Queen of England. So therefore there is a common legal system. So you can make a comparison of those legislations in 2 different Commonwealth countries. You can also make a comparison of the different democratic countries vis-a-vis the framework of the agricultural laws or farmer laws. These are the different homework which I am suggesting to you. Somebody can do a collection of some more information about the agricultural laws which were introduced prior to independence. You will come to know that the agricultural reforms which were made during the Mughal period, which were made during the period of Chhatrapati Shivaji Maharaj, that can be compared and that can be brought up to this level. You can also make a comparison that after 1857, when the Queen gave a proclamation and then thereafter the Queen's rule started in India, different legislation came. So we can refer about the Bengal Act of 1859 or the Permanent Settlement Act of 1793 or even the Famine Commission of 1880, or even if since we are considered about the Vidarbha region, so therefore CP Tenancy Act 1920, so many different legislations are there. You can apply your mind with reference to those different provisions of law, which will be useful for throwing further light with reference to this topic. Having said about this, now it's a time to wind up. And you will come to know that this is a altogether different and separate distinct topic, which was quite interesting. And almost more than 50 minutes, I am sharing my thoughts with young friends who are on that side. I must tell you, this session is not a complete in itself, but I'm sure this will be sufficient enough to give you some kind of a stimulation, some kind of catalytic work. This will act. This will be giving some kind of a triggers, and I'm sure this will be some kind of a inspiration. See, I am having roots from the rural part of the Maharashtra. My forefathers were agriculturists, but now I am settled in Mumbai. But ultimately, everybody is having his own battlefield. Somebody may choose the agricultural field as a battlefield. I have chosen my black coat and the black robe in the court of law as my battlefield. Everybody is having his or her own stories. But don't forget, we are having a debt of this agricultural gentleman who is agricultural laborer, who is the agriculturist, who is a farmer. He is feeding us. And therefore, it becomes our duty to respect to his feelings, to consider his problems sympathetically and find out a robust solution to the present situation. I'm sure why only lawyers should get the benefits of the liberalization. Why not agriculturists? So therefore, the shortcomings of the trade and commerce system, shortcomings of the marketing system, those will have to be overcome. And with reference to that, according to me, the organizers have rightly chosen this particular topic. So therefore, I must congratulate them for choosing an accurate topic with reference to the today's relevance, and allow me to leave it open, leave this topic open for further debate, because I'm sure this particular session must have triggered certain questions in your mind. Let me tell you a word of disclaimer. I do not claim that my answers will give you a full stop with reference to all your questions, but I'm sure we both will jointly find out the accurate answers to your questions. With this, I express my deep sense of gratitude to the organizers who gave me this wonderful opportunity. There is one more proud feeling. My guide of PhD, he inaugurated this seminar, and Dr. Durgambini Patel, who was HOD of the SPPU when I was a PhD student, was the first session resource person. It also makes me more proud. And with this, I wish you a quite long and healthy stay at your home. Let us utilize this time for self-improvement. Stay home, stay safe. Thank you.
Thank you, sir, for your very thoughtful and provoking and interesting address. We shall now proceed with the questions of students. I now request Sakshi Mehta to kindly pose the questions.
Thank you, Janki. So, a few students have some questions regarding your seminar. So, if you allow me, I'll like to ask you those questions.
Please go ahead.
Thank you, sir. The first question is that it has been contended that the bills have not, in fact, been passed by Rajya Sabha because the majority had not been determined in accordance with Article 100. What are your views on that?
All right, let us go back to Article 249. 249 gives power to pass the bill in case of a national interest, even if it is in the state list. There you will find two-third majority is required. But since this this bill is not tabled by taking a recourse to Article 249, there is no need of passing that bill from Rajya Sabha with two-third majority. Apart from that, this being a non-finance bill, this can be passed by the Lok Sabha. So therefore, there is no need to place it before the Rajya Sabha. Next one, please.
Thank you, sir. The next question is that the Constitution grants us the right to protest, but are the ongoing protests justified in the pandemic situation where national highways are being blocked, creating hurdles to ambulance and emergency services? So, in this situation, whether relying on judicial review would be a better course of action?
I gave an answer indirectly because I pointed out that in a bunch of petitions, there were some petitioners who approached the Honorable Supreme Court on the same line, saying that during this pandemic situation, blocking of the highways and then creating a ruckus, this is the thing which should be avoided. And therefore, a judicial review of such action is also permissible. That has been done even in past. There is no difficulty. It is permissible. And you rightly said that freedom of speech and expression is there, but that is not at the cost of the life of the several persons. So therefore, the answer is already there. Next question, please.
Thank you, sir. The next and the last question is, on what basis can farm laws be further challenged in Supreme Court?
You said further challenge. I'm sorry, there is already a challenge. And my appeal to the question, the person who has raised the question, please collect copies of those different petitions. You will come to know that the different challenges are there. And with a sense of responsibility, I can say that even if you find that there is some other challenge which is remaining, you are most welcome. The Honorable Supreme Court will be welcome. I'm sure large number of advocates like me, they will be happy to take wakalatnama of those students who wish to point and place different other angles of further challenge to the farmers' law before the Honorable Supreme Court. Thank you.
Thank you so much, sir. This marks the end of the Q&A round. Janki, over to you.
Thank you, Sakshi. Now, since we are done with the question and answer round, we will proceed to the vote of thanks. I would like to thank Advocate Dr. Uday Warunjikar sir for sharing his insights on such an important issue of constitutionality of agricultural laws with all of us. Sir, today's lecture has indeed highlighted Farm Bill and why new legislation was introduced. And as you rightly pointed, how impartial application of minds is essential. So you rightly pointed out that those who have to challenge constitutional validity of constitution have to come up with strong case to meet up such presumptions. And sir, we will definitely do homework given by you about Article 18 and 19. Is it ultra virus or not? And the validity of constitutionality independently and come to conclusion after that. Sir, once again, thank you so much for sparing your time and sharing such deep insights with all of us.
Thank you all. Thank you so much.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Please join at 2 p.